All right, so we're on the record in docket 23-02832. That is people of the state of Michigan versus Marquise Demeyers. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Ferguson.
Good afternoon, or good morning, Your Honor. Assistant Public Defender Stephen Feigelson, bring it back from Marquise Demeyers, who's standing to my right this morning.
And sir, you are Marquise Demeyers, is that correct?
Yes.
All right, thank you. This is the time set for a pretrial in the matter, or a preliminary examination in the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. Mr. Feigelson was just recently appointed, I believe this week, and there is some outstanding discovery that needs to get over to him. So I believe this is going to be a waiver for 21 days and set the preliminary exam out.
All right, is that a fair statement, Mr. Feigelson?
It is, Your Honor. We probably need a probably 2-3 week adjournment to make sure I get good.
All right.
We're waiting on the CPS records, Your Honor.
May I inquire of your client of his waiver of the 21-day
You
rule?
may, Your Honor.
Mr. Demeyers, you understand, Demeyers, you have a right to a prelim within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You're represented by attorney Stephen Feigelson, and he would be here to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that?
Yes.
It's my understanding that Mr. Feigelson was just appointed. There's still some discovery going on that Mr. Feigelson has to review in order to zealously advocate for your defense, and therefore you're moving to waive your right to a prelim within 21 days. You're not waiving your right to a prelim in general, just within that 21-day period. Is it your wish today to waive your right to a prelim within 21 days?
Yeah.
Do the people also waive their right to a prelim
We
within?
do, Your Honor.
All right, I find the waiver of the 21-day rule to be knowing, voluntarily, accurately made. And you indicated, Mr. Feigelson, about 3 weeks.
Yeah.
All right. March 21st at 8:30.
And I can make that work.
All right. Anything else for the record in 23-02832? Ms. Wilson,
That's from the people.
Mr. Feigelson.
Give me Judge, I mean,
I'm already.
oh, you're right, thank you. I was gonna talk about bond, but I think he's already on a sentence, so.
All right, so he's collecting time.
Right.
Well, I believe he's on a PR bond in this matter, and he's either got a hold or was just sentenced in a circuit court matter.
Yeah.
Do you want to revoke the PR bond so to make sure he's collecting,
Yeah, that might be a good idea, Judge.
just to make
No
sure?
objection.
Okay. So in that way you know you're getting credit for any time in on this file,
Okay.
which I think is a good idea. So I will set bond at $5,000, 10%.
You know, how long was, when's your sentence?
I'm a trustee now, so May 10th.
I would just ask that if we could, when he gets, finished the other sentence, if it convert back to a PR. bond.
All right, you let me know, okay? You let me know, because we still have a prelim to do, but at least we've got a block of time that we know he's getting credit for on this file.
We can deal with that when the prelim comes down.
All right, so bond is set at $5,000, 10%. Anything else for the record in docket 23-02832, Ms. Wilson,
Nothing from the people.
Mr. Feigelson?
Nothing for the defense.
All right, you're all set, Mr. Myers.
All right, thank
Then Ms. Riemann Schneider is on.
Yes.
That's Mr. Silverthorne's client, I
Yes.
think.
And I believe he's going to be a waiver to circuit.
All right. Should we go on, did you want to try to, see what we're doing on Riemann Schneider?
Yeah, I guess Mr. Feigelson is here, so we should do that.
Okay, well, Mr. Feigelson, did you need to speak with Ms. Riemann
I
Schneider?
don't, Your Honor. I spoke with her this morning, Your Honor. I do apologize for her being on Zoom, but she advised me she's very ill and I don't want to risk getting other individuals sick this morning.
So she has not waived her 21-day rule.
Actually, she did, Your Honor. We had, this is a continuation
Oh,
of an
she must
exam.
have. Yeah, we started.
And I think we were waiting to see if necessary witnesses people proceed their exam. I don't know if any of those witnesses are, Your Honor.
We have a bond violation on this too. So we're holding both till March 1st. Is that right?
Yeah.
Yes.
All right. Well, let's call it on the record. So we're on the record in docket 22-01-220. That's People of the State of Michigan versus Mary Lou Riemenschneider. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Ferguson.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson, appearing on behalf of Mary Lou Riemenschneider, who's present over Zoom this morning, Your Honor.
And ma'am, you are Mary Lou Riemenschneider, is that correct?
Yes, sir.
And you can hear me all right, Ms. Riemenschneider?
Yes, sir.
All right, this is the time set for a continuation on a preliminary examination that we'd already started. We'd had 2 witnesses testify. I granted the motion for adjournment. We set the prelim for today and the bond violation for today. Ms. Wilson, how are we proceeding, or if you want to make a record?
Thank you, Your Honor. At this time, the witnesses that were needed are not present. The people will be requesting that the complaint be amended to a misdemeanor and the felonies be dismissed.
So that would be amend.
So the only issue I take with that is I think if we listen to the testimony that we heard at the prelim, I know a misdemeanor carries forward with the felonies, but I didn't think there was even enough evidence for receiving and sealing. The necessary witnesses to meet those elements aren't present today. So if we continue to adjourn this out, set it for a misdemeanor pretrial, I'm not certain if these witnesses are going to even appear again.
What are the nature of the misdemeanor?
The misdemeanor is the receiving and concealing of stolen property. And I believe that we don't need the witnesses that did not appear today in order to meet that charge. So we would be requesting an amendment of the complaint.
We received testimony from Tricia Passion and Damon Pulver. So that would be 200 to 1,000
Yes.
pursuant to what PAC code is that?
750.5354A.
All right, and with that understanding, you would dismiss the underlying felony, and I guess we'd set it for pretrial.
Correct.
All right.
Just I still think if you listen to the testimony of the Ms. Cassidy, she's never going to be able to say anything about receiving and sealing property. All she says is that property was stolen. She's not certain who took the property, Your Honor. So
Right. And we adjourned. I don't know what the status of the cases at the pretrial or what will happen if additional witnesses will be present for the receiving and concealing. This was started as a home invasion, count 1 and count 2, and then the misdemeanor 1 year. So the home invasions were the probable cause determination, and so I'm gonna take that. I'm gonna take the people at the dismissal of those 2, and we'll set the receiving and concealing, which I don't know if we heard any evidence on other than the property was stolen. And then the officer responded to the call.
It was not part of the original charge, and it was, it's a misdemeanor, so it would not be a part of the probable cause determination. So we did not have witnesses necessary for that.
Right. Yeah, I would expect that you need some witnesses for counts 1 and counts 2, the home invasion.
Correct.
So I will grant the request to dismiss counts 1 and 2. You have that, Nolly?
Correct.
We'd go forward on count on count 3, which is the misdemeanor.
May I approach, Your Honor?
You may. And then we'll. Thank you. And then we'll set that for pretrial. So I'm in possession of docket 22-011-01220. Counts 1 and 2 will be dismissed at this time by the people of the state of Michigan. We'll go forward on count 3, which is the misdemeanor, receiving and stealing property. And we'll set that pretrial for
March 18th at 9.
March 18th at 9 a.m. We still have an outstanding bond violation. Is that a GPS bond violation? It looks like.
I believe so.
All right. So Ms. Riemann Schneider, 2 of the counts have been dismissed. We've set the misdemeanor count for pretrial. Let's make that, and that pretrial is March 18th. You'll get that live at the Valencia address. Is that still a good address for you?
Yes, sir.
All right. You should come live on March 18th, since we'll be dealing with the pretrial. That's not so much the requirement, but the bond violation will need you here so that you can address any bond violation by March 18th. All right, ma'am?
Yes, sir.
All right. And then counts 1 and 2 are dismissed pursuant to the nollie pros after the beginning of the prelim. Anything else for the record? 22-01220, Ms. Wilson.
Nothing from the people.
Mr. Feigl.
Nothing from the defense.
All right, thank you. All right, Ms. Riemann Schneider, we'll see you on that March 18th at 9 a.m. date. Zoom will not be appropriate on that date, okay?
No, I appreciate it. I'm sorry. I'm so sick.
All right. We'll see you on that date. Thank you for your appearance today.
Thanks, Judge.
Thank you.
You too. All right, so we're on the record in docket 24-00204. That is people of the state of Michigan versus Kenneth McMullen. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Don.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Kenneth McMullen, who is present and standing to my right.
And sir, you are Kenneth McMullen, is that correct? Thank you. This is the time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. McMillan would be waiving his right to a preliminary exam.
All right, and is that a fair statement, Ms. Donnelly?
That is correct, Your Honor.
And at this time, negotiations are to continue in circuit court.
That is correct.
All right, Ms. Donnelly, may I inquire of your client, Mr. McMullen, of his waiver of the preliminary examination?
Yes, Your Honor.
All right, Mr. McMullen, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Was previously adjourned for just cause. That preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by attorney Sarah Donnelly today, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
I do, Your Honor.
It is my understanding, it is your wish today to waive your right to preliminary examination, have this case continue to circuit court where negotiations would continue.
Yes, Your Honor.
Is that your wish today to waive your right to a preliminary examination?
It is, Your Honor.
Thank you. And Ms. Wilson, is that also your wish to waive the people's right to preliminary examination?
The people unconditionally waive the right to a preliminary
All right.
examination.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. I will indicate the negotiations are to continue in circuit court, and I will have the parties sign the bind over documentation. And a couple of things came out of the judge's meeting. Nothing, but. All right, I'm in possession of the bind over documentation. I'll indicate that the examination was waived on today's date. All the parties have signed the documentation, and I will sign it to that effect. So, Mr. McMullen, your time in district court is done. You're now in circuit court. Case is bound over as charged. Please get your next date from your attorney, Ms. Donnelly. She will provide you with your next circuit court date for arraignment, okay?
Thank you, Your Honor.
We're not going to appear for arraignment.
All right, so you'll probably waive arraignment in circuit court, but you're 2 to 3 weeks, probably 2 to 3 weeks out at least, all right? Anything else for the record in 24-00204, Ms. Wilson?
Briefly, Your Honor.
You got to shut up. You got to shut off your phone.
At the last hearing, there was the issue of property from one of the witnesses that had been left at Mr. McMullen's apartment. And Your Honor wanted to wait until today to address that issue. I was hoping we could address it today.
I have on March 1st, I said there was no sale of contested property.
Correct.
Okay,
And I don't believe the ownership of the property is necessarily contested.
right.
It's just that it's at Mr. McMullen's house.
So do you want a one-time order to go back to the house with the sheriff to get the property? And then not be in violation of the no contact?
I don't know if
I don't know that the sheriff will do it. I don't know if it's possible to do some kind of arrangement where he drops it off at a police station and then the witness can pick it up.
Well, I was thinking also if he drops it off at our office.
That would
we can
work as
That would
arrange
work.
for the
Yeah.
property to come to
Mhm.
our office and then someone can come to our office and get, I don't know. If it'll
So
be
if we can maybe get a date that needs to be dropped off by.
Yeah, can we get a list of, do we have a list of the property or like specific things? Like I want to make sure, because I don't want, my concern is that, I only want the property that belongs to her, the things that are in dispute.
Correct.
No problem with handing over the things that aren't in dispute. If there's a dispute over anything, I think we obviously need to handle it with the judge. So
Right.
yeah, if we can get an itemized list and then I'll coordinate
I
with
can get
him
a list, yeah. Mhm.
to get it to my office.
Perfect. All right, let's do this. So, Ms. Donnelly, you'll be responsible for getting an itemized list to Ms. Wilson. And then if one.
Other way. I'll get the list
You'll
from
get
the
the list
witness
from the
to
victim,
Ms. Donnelly,
to
yes.
Ms. Donnelly. And then Ms. Donnelly, you will confer that that's the correct list, and then the property will be dropped off at the public defender's office
Yes, I'll make those arrangements.
for the victim to, and then we don't have to, we
Yep.
don't have to worry about a violation of the order or anything along those lines. All right, I'll indicate that in the notes that the order to drop off property at PD office, itemized list from prosecutor to public defender. And then you can go from there. I think we're all on the same page. We don't want a violation of the no contact, but we also don't want any problems with this turning into
Yeah.
that's a dispute of property.
Mhm.
And that's what we're trying to avoid. All right. Anything else for the record in 24-00204, Ms. Wilson?
Nothing from the people.
Ms. Donlin?
Nothing for defense.
All right, Mr. McMullen, you're all set. Your next court date will be in Circuit Court at the Grady Porter Building, okay? All right, thank you. Mr. Silverthorne, are you ready on Mr. Is it
Yes, if I
Collins?
got approached with Ms. Wilson.
All right, he was online. Now he's not.
Oh,
Yeah,
it's not his fault. It's fine. I just tried to call him and I probably couldn't because maybe he got offline because he saw my number coming in.
right. Do you want some time to talk to him?
I called him this morning to remind him of the hearing and he was clearly in a car. He was en route. I said, no, I think we can do this. I was thinking it was a PCC today.
Right,
And knowing what the result was, we're gonna waive based on a plea.
right.
And so I tried calling him at your clerk's instruction and he couldn't pick up because he was online here.
If you get him here by Zoom or however, we can, yeah, just let me know.
Yeah, like I said, I had a lot of PCCs today.
Yes.
His was the one PE,
I got it.
my problem, not his.
Right, right. You're good. Let me have Mr. Then you let me know, okay?
Yeah.
Because I know we have a prelim with Mr. Austin. Is that right?
Possibly, it sounds like there might be an attorney's change happening.
All right, how about-
I just emailed Mr. Austin back.
All right. How about,
I believe Mr. Omari is going to be a waiver to circuit.
all right, and that's Miss Wanji.
Is what? Yeah.
Did you want to do, is
Let's
that,
do Omari.
let's do Amari? All right, so we're on the record in docket 23-03885. That's people of the state of Michigan versus Kevin Omari. Will the parties please introduce themselves for the record? Miss Wilson,
Abigail Wilson for the people.
Miss Wanchi.
Melania Duanji for Mr. O'Malley.
And sir, you are Kevin Omari, is that correct? Thank you. This is the time set for preliminary examination. Miss Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a waiver of the examination of the circuit court.
Right. And is that a fair statement, Miss Wanchi?
It is, Your Honor.
So this is a waiver bound over as charged with negotiations to continue. Is that correct?
That is correct.
All right, Ms. Wanji, may I inquire of your client of the waiver of the preliminary examination?
Yes, Your Honor.
All right, Mr. Omari, you understand you have a right. Well, you have a right to preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Melanie Wanji, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
So,
It is my understanding today, you wish to waive your right to a preliminary examination and have this bound over as charged with negotiations to continue in circuit court, which is the trial court. Is that correct? Say,
yes, Your Honor.
okay, so it is your wish today to waive your right to a preliminary examination. All right, and Ms. Wilson, you are also waiving the people's right to a preliminary examination.
The people unconditionally waive, Your Honor.
All right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the bind over documentation for signature. All right, I am in possession of the bind over documentation. I'll indicate that the examination has been waived on today's date. And I will sign the paperwork accordingly. Mr. Omari, your time in district court is done. Your next date will be in circuit court at the Grady Porter Building. Please keep in contact with your attorney, Ms. Wanji, and she'll provide you with what date, whatever date that is. I'm assuming you might waive that date, but you'll get the next date for your appearance from Ms. Wanji, okay? All right, anything else for the record? And 23-03385, Ms. Wilson,
Nothing from the people.
Ms. Wanji.
Nothing, Your Honor, thank you.
All right, thank you. You're all set. Thank you for your appearance today. And Mr. Wanty has Brown and Jackson, right?
Correct, and I believe Brown is going to run. Jackson,
Jackson is here.
right? Okay.
Freeman Strider, we did.
Mr. Austin, have you decided what you're doing?
I understand.
Want to do that? Sure. We're ready on Gatlin.
Okay, Gadlin. That is Dominic Gadlin. All right, so we're on the record in docket 24-00396. That's people, the state of Michigan versus Dominic Gadlin. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr. Austin.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Gadlin. He's standing present to my right.
And sir, you are Dominic Gadlin, is that correct?
Yes, sir.
Thank you. This is time set for preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that Mr. Gatlin would like an adjournment and waive his 21 days.
And is that a fair statement, Mr. Austin?
That's my understanding, Your Honor. Speaking with Mr. Gadlin, he seeks an adjournment of the preliminary examination so he can look into retaining counsel. Of course, that would require him to waive his right to have a timely examination so he could explore that option.
All right. May I inquire of your client of the waiver of the 21-day rule in order to seek private counsel?
You may do so, yes.
All right, thank you. Mr. Gadlin, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Brian Austin. And he, of course, would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding that you seek to waive the 21-day rule and have this case adjourned so you can seek private counsel to represent you concerning this matter. Is it your wish today? You wouldn't be waiving a preliminary examination right in general, just to have it within that 21-day period. Is it your choice today to waive your right to a prelim within 21 days?
Yes, sir.
Okay, and it's my understanding, sir, you intend to seek counsel at this time? Do you have a name of who you're interested in seeking?
Brad Black.
Okay. So I'll indicate that you're seeking Mr. Blackman, and that was the name you gave. I'm not going to hold you to that, but. And we will reset. We will reset the preliminary examination for Mr. Blackman to file an appearance to get discovery with the new attorney so that they can zealously advocate for you. Okay, sir? How 2 to 3 weeks, I would think. Yeah. So I would think 2 to 3 weeks for any new lawyer to get on board.
March 21st.
Did you say 21st?
March 21st at 9:30. And Ms. Wilson, do you have any objection to the adjournment for seeking private counsel?
We do not.
All right. All right, so the waiver of the 21-day rule has been found to be knowing, voluntarily, and accurately made. I would get on seeking new counsel right away, so the sooner you get him on board, the sooner that he can get all the discovery and anything from the prosecutor's office. Anything else for the record in 24-00359, Ms. Wilson?
Nothing from the people.
Mr. Austin?
Nothing additional, Your Honor. Thank you.
Thank you. All right, Mr. Gatlin, you're all set. Thank you for your appearance today.
Thank you, Judge.
Thank you, Mr. Austin.
Okay. I think we're ready on Mr. Payne.
Mr. Payne. Is that Mr. Sartz?
Mr. Cornish is covering for
Okay.
Mr. Sartz today. I can go down and see if he's available.
All right. I didn't see him in here,
He's
so
running a prelim in judgment camp.
Oh,
is he?
Okay.
Then-
Mr. Yeah.
Cornish?
Yeah.
Okay.
I knew he was down there. So.
I didn't see him in here, so. And then Mr. Palmer, you have,
I have Mr. McGriff.
Mr.
Your Honor.
McGriff?
Mr. McGriff is present.
Yep.
so, I've got Ms. Wanji's cases. And then Mr. Cornish and Mr. Palmer. Mr. Silverthorne's contacting Mr. Collins.
Yeah, I don't believe I have witnesses on Mr. Jackson, so I guess we can.
All right, that's Ms. Wanji's client. Is that right? Did you want to check the hallway?
Yeah,
All right. Is it? All right. Can you grab that and as long as he's here? It's the one that we knew we were going to set for prelim. That's it. The other one's a misdemeanor.
Oh.
I know, might be.
there's you four in here.
Was a P, oh, he was a no-show on a PCC.
Or Mr. Jackson.
All right, so I have two files on Mr. Jackson, one from yesterday that we're gonna clear up, but let's go on today's file first. All right, so we're on the record in docket 24-00164. That is people of the state of Michigan versus Moreno Jackson. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wanji.
Daniel Duwanji for Mr. Jackson.
And sir, you are Moreno Lee Jackson, is that correct?
That's correct, sir.
Thank you. This is the time set for a preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I have no witnesses here today, so I expect a motion from the defense.
Ms. Wanji.
Then I would ask the court to dismiss the case without prejudice.
And witnesses were subpoenaed for today.
They were, Your Honor.
All right. So I will grant the motion to dismiss. Without prejudice, which means the people could reissue if they choose to, but realistically, for our purposes today, the case is dismissed. And you're also, as part of this was the PA 53 violation, that is also dismissed.
I believe so, Your Honor. That is the basis of the other charge.
It's the no contact order, I think.
It wasn't a no contact, it was another offense that was picked up.
Okay. I will await the Nolly Cross for the offenses indicated is dismissed without prejudice. Anything else for the record in docket 24-00164, Ms. Wilson?
Nothing from the people.
Ms. Wanji?
Nothing, Your Honor, thank you.
All right, Mr. Jackson, you're all set on that file. And then I have one from yesterday that we should look at. You were set for probable cause conference on docket 24-00425. And then you failed to appear on that.
Sir, I came here. I spoke to a gentleman at the office. He said he didn't know nothing about it in court.
All right, what was his name?
It's just a gray-haired white man that works at the clerk's.
All right, did you take a look at any of the monitors to indicate
No, I
whether your
didn't.
name was on there?
And honestly, I had so many court dates, I didn't even know.
All right,
I was coming here because I had a 3 to 10 day
But-
for a driver with no license.
but we issued a bench warrant on that date, but we did it with a 48-hour hold because we knew we were gonna see you today,
Yeah.
okay? And then if you didn't appear today,
And then
we just do a bench warrant on everything. But since you've appeared today,
And I paid the bond, the PR
okay,
bond.
so any bench warrant will be quashed. But we will get you a new date for that PCC.
You just let me get that in paper, so I'll lock it in my phone, please.
All right, so what's the new date for prelim?
Prelim date is still on for 3/7.
Okay.
He's not represented that case. Ms. Wanji.
No, I got Fred Blackman. I'm not gonna talk to him right now.
All right, so your plan is to retain Fred
I
Blackman
already
for
paid him.
March
He's acting
7th?
like I didn't pay him.
Okay. So
I'm not gonna talk to him right now.
retain. All right. So we'll await an appearance from Mr. Blackman but your prelim is set for March 7th, 2024, and then you'll receive notice right there. So you have that, okay?
8:30.
Yep, at 8:30,
First case dismissed, and then I come back for this.
correct.
Thank you, Mr. Flores.
All right, anything else for the record? 24-00425, Ms. Wilson.
None from the people.
All right, you're all set, Mr. Jackson. We can
Do
take,
we want to do McGriff? Okay. You have a couple of exhibits.
all right, so go ahead and give those to Wendy. And which file are we going?
So I believe we can do them together because it's the same offense. The bond violation and
Oh, one's a
the
bond
felony.
violation.
Yes, one was a bond violation and his misdemeanor, and then the basis of the bond violation is another charge.
So which are the exhibits for, please?
They're for let's start with the prelim.
Okay.
And then we can recognize that, yeah. Because we'll do the prelim first and then
Mhm.
we'll have the testimony.
Yeah, but they're all. You're just gonna skip through them. Okay. I would assume so. Cutting color.
Sure, yeah, it's probably better. I'm not allowed to print this one.
All right, so we're on the record in docket 24-00405. That's the People's State of Michigan versus Jabriel McGriff. For Jabriel McGriff, will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Thank you,
And
Your
Mr.
Honor.
Palmer.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. McGriff, the gentleman who stands to my right. Judge, just as a preliminary matter, I will say it's my understanding Ms. Wilson intends to enter 3 exhibits today. Quite honestly, I think they're all admissible anyway, so the defense will go ahead and stipulate to
All
them.
right.
So I don't know that there's any need to spend time laying
All
foundation
right.
for something that's admissible.
All right, so pursuant to stipulation, exhibits 1, 2, and 3 are admitted. Sir, you are, and correct my pronunciation, is it Jabriel McGriff or Jabriel McGriff? Jabriel McGriff. All right. This is the time set for preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to proceed with the exam today.
All right. Are there any preliminary matters to come to the court's attention before we get started, Ms. Wilson?
I just believe the sequestration of witnesses. I do believe I have some witnesses here in the program today.
All right, and so I'm going to let you take care of that. Any witnesses that are here in the courtroom for this matter shouldn't watch another witness testify. Mr. Palmer?
I would also agree with the sequestration order, Your Honor. Other than that, I have nothing. No
All right.
preliminary matter.
If anybody comes in the courtroom, you know the case. Ms. Wilson, Mr. Palmer know the case better than I do. Bring it to the court's attention, and I'll make sure that they don't watch another witness testify with that understanding. So I'll grant the motion of sequestration. Anything else, Ms. Wilson?
Nothing from the people.
All right, you may call your first witness.
Thank you, Your Honor. The people would call Hayden Harvard.
All right, Officer Hart, is it?
We're actually going to start with Mr. Davis.
All right, so this is Chris Davis.
John Hayes.
John Hayes, oh, sorry.
Mr. Hayes, why don't you come back here? Please spell and spell your first name and your last name for the record.
John Hayes, JOHNHAYS.
All right, please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, have a seat there. The microphone is for recording purposes. So for my court officer, so please project to the back, and Ms. Wilson, you may proceed when you're ready.
Thank you, Your Honor. I'm sorry, can you repeat your last name?
Hayes,
Hayes?
HAYS.
Okay. Mr. Hayes, are you currently employed?
I am.
Where are you employed?
Judicial Services Group.
And what is that?
We provide electronic monitoring equipment to courts and sheriff's offices across the country.
And what are your general duties?
I oversee the entire operation.
Okay, so in the course of your duties, do you get some kind of alerts as to violations of these monitoring devices?
We do.
Okay, did you receive an alert on 2/15/2024 around 6 p.m.?
Alert was at 4:30 a.m. And that was for what we call a backplate tamper on our GPS device.
And what does that usually mean?
It means that the device was removed. Specifically, I have a device in my hand, and I can explain a little bit better. So here's a GPS device. Most times when people see it, they see it affixed to an ankle. So it's one piece similar to this. When it is affixed to an ankle like this, there's tamper technology built in the strap, which is what I'm holding. So you'll see a fiber optic line going through it to tell us if someone cuts the device off. And then on the back of the device, there is a compression button right here that shows if this back plate is affixed. So I will push it, here, click. That is the compression. So when it is on the client, that button is compressed. If for any reason the device is removed and that pressure is released, we get what's called a back plate tamper, which tells us that the front of it is not in contact with the back of it anymore. And the only way to accomplish that is to remove the device.
Right. For the record, the witness was working with a model, a demonstrative model in which he was showing us. It's not an exhibit, but it is a demonstrative model. Any objection, Mr. Palmer, to the witness's use of the demonstrative model?
Well, I don't have any objection to the use of the demonstrative model, Your Honor, but I do have a concern that I think he's testifying about technology, some sort of a report that was submitted apparently based on a trigger for this backplate or whatever, and I've never been provided with that. So I don't know that I have the ability to cross-examine. That kind of comes as news to me, I guess, that the report that I've received has a substantially different allegation. There's talk about a broken piece of the tether in my report, but nothing about this other backplate tamper and whatnot. And I think that substantially changes what we're talking about and also my ability to cross-examine.
All right, so let's do the direct examination and we'll take a break and see if Mr. Palmer wants more time for the cross-examination. I understand the nature of it. The witnesses explained that it is the pressure that's relieved sends the signal. And there was an initial report based on this that it was broken. And so what broken means may be one thing to one person and another thing to another person. So with that understanding, I'll let Mr. Palmer hear the direct testimony, and then we can take a break and see how we want to go forward. You can go ahead, Ms. Wilson.
Now, on that February 15th date at around, I believe you said it was around 4 in the morning that you got that alert. Do you recall who the alert was for?
Yes, it was for Jabril McGriff.
And in the course of your duties, do you ever either meet with the individuals with the tether or see some kind of photo of that person?
Yeah, so it's dependent on what type of alert there is. In both the cases that I had explained earlier with a strap tamper, meaning the device was cut, or a backplate tamper, our first contact is generally the client.
Okay.
We attempt to contact them, ask them if something happened. We've had cases before where something's been dropped on it. There's been different issues, and we can identify that through contact. In a case where we cannot make contact with the defendant, we then contact 911, Ingham County Central Dispatch in this case, and request that an officer respond.
Okay. Now, in the course of your employment, have you ever met Mr. McGriff?
I have not.
Okay. Do you recall approximately the address that this tamper was located at?
I do not have that information. I do believe it was at his home, but I cannot verify that.
Would reviewing your report refresh your recollection of the address?
The report I have just has the information, does not have the location information. Okay. Obviously, I could review that at a later time, but I'm not sure.
Okay. Now, at some point, did you receive contact from officers at that location?
Yes, we received a phone call at 5:23 that the tether was still on him. I'm going to object at this point. I think that's hearsay testimony.
Response, hearsay?
I don't believe it's necessarily hearsay, Your Honor. It's being offered as indication of what Mr. Hayes did next.
So it's offered for effect on the listener?
Correct, yes.
So it's not being offered substantively?
Correct.
So anything said to the witness won't be taken substantively, only offered for the effect. All right. With that understanding, and I understand the hearsay objection, the hearsay objection is overruled. I won't be using any testimony given to the witness by the officers as substantive evidence.
Now, at some point during your investigation into the matter, did you review photographs of the device that had allegedly been tampered with?
We did.
All right, permission to approach the witness, Your Honor.
You may.
All right, now, Mr. Hayes, I am handing you People's Exhibit 1 through 3. And you could just take a quick look at those photos. Are those the photos that you reviewed previously?
They are.
And can you describe a little bit what is in those photos?
Yes, it shows the device that was affixed to the defendant and apparent damage to the top tamper clip, which is what we use to secure the device to the client.
Okay, and can you describe exactly what that device is that you mentioned was tampered with?
Correct. So again, I'm going to use the model device that I have. I'm going to hold it up and explain. So once that piece is together, we have a top tamper clip, which is what I'm holding in my hand right now. You will see the top has a groove very similar to where it goes. It has to fill that completely. So I'm going to put the top pin in. You will see it is now flat. The next piece is the bottom piece that we put in, and it grabs the top piece similar to a groove like this. Once that is together, the device is secure. You'll see on the bottom, it has a clip. On the top, that clip is flush.
Okay, so, and you made a motion with your hand that the lock is a locking device with two like hinges.
Correct,
Is that
Your Honor.
correct?
Correct, and that is inside of the device, so you cannot see that that action is happening.
Okay.
Once that is done, there is nothing you can do to get that top clip out. I could sit here for 1,000 times with my nail and try to pull that top clip out. It's not possible.
And you know that based on your experience in training?
Correct. I've trained hundreds of law enforcement officers across the country. I've done this demonstration. I've handed it off to multiple. I could sit here all day and do this.
Okay.
Or I could take a tool and remove it the way that we would remove it by flipping the bottom. Or I could try to, and you can see with the effort, and I clearly know what I'm doing here, it still takes a lot of effort to get under that device to try to break it off. Once it's broken off, and this part is very important, in order to break it off, you have to snap it. It's damaged. Okay, this would then allow for this device to be removed. If this was actively on a client right now, I still couldn't remove this. The only way to remove it is to then push it down, take the bottom clip out, and it still would take effort, and it's that way by design. Once that is removed, that's when you hear that button come uncompressed. That's what generates a backplate tamper. You just saw all the effort that it takes for me to do that. It cannot happen on accident. That is my belief. In this device, I'm gonna object here. I think now we're getting into this. I mean, he just testified, for example, he said that's my belief. I think we're getting dangerously close to opinion testimony. This witness has not testified that he specifically witnessed this tether in particular. Unless we're going to qualify him as an expert, I don't think his opinion is relevant or can be admitted to this court.
Ms. Wilson.
Thank you, Your Honor. So he has observed at least photos of this specific tether, but as to his testimony as to how it can be removed, it's his opinion based on his extensive training with the tethers that are used, like the one that was used in this incident. So I do believe that it is admissible from his training and experience.
Mr. Palmer.
And I would still say, Your Honor, it's still opinion testimony,
right,
and it's still inadmissible if given that it's opinion testimony, and this individual witness has no firsthand knowledge. This is information that's passed to him based on training and experience and his experience in other tethers. As I say, I don't think opinion testimony is admissible.
Well, it does sound like expert testimony in this matter, and he's not been admitted as an expert, but I can bifurcate it in regards to this witness is testifying as to the device in general and his opinion on the device, but not how it relates to Mr. McGriff, because he didn't, the device was found by law enforcement on Mr. McGriff. Mr. Hayes is talking about his understanding of the tether system, and I think that's allowable. So
I guess the other objection I would place on the record, Your Honor, is that according to the report, as I already indicated, it sounds like there's at least one report that was never turned over to me. I'm not suggesting, to be clear, I'm not suggesting that's Ms. Wilson's fault. Nothing of the kind. But the other issue here, Your Honor, is that this individual, Mr. Hayes, at least according to the report that I received, Mr. Hayes is not the person who reviewed the photographs at the time of the incident, nor had the interaction with the police officers. So Mr. Hayes's, as far as I can tell from all the materials that I've received, Mr. Hayes had no involvement in this other than that he's overseeing JSG. Now, I understand why he's been called to testify today. I understand that he can testify to the tether itself or how a tether works, but this is not the individual who had interactions with police officers. And again, I would suggest that particularly given that he's not the individual who talked about evidence and those kinds of things, that he's not permitted to testify regarding specifics of Mr. McGrath.
Ms. Wilson.
I believe there was testimony that he had reviewed the photos previously. So even though he wasn't necessarily the individual that took in the information from the tamper report, he was a part of the investigation and the reviewing of the tamper.
All right, so I'm going to take this motion under advisement because to me, obviously, there's another witness in this matter, and I'll wait and see what the other witness testifies to. I think this witness can testify to the nature of the device, how this device works, and then any exhibits that would go towards this device. Whether he links it up to Mr. McGriff is another thing, but we'll wait on to hear all the testimony and not piecemeal it in regard to the prelim.
And I'm sorry, Judge, I do just want to make one further record. I will note that Mr. Hayes, I've cross-examined Mr. Hayes before, so I'm familiar with him, but I will note that Mr. Hayes is not mentioned anywhere in the report, but additionally, he's not listed as a witness anywhere on the complaint. So because he's nowhere is he referenced, and he's not on the complaint, I don't know that he's a proper witness to have at this hearing even to begin with. In other words, I think it comes as a bit of a surprise to the defense because we were not prepared for Mr. Hayes to be here. He's not referenced anywhere. He's not an endorsed witness. I've got no way to prepare to cross-examine him. And additionally, it sounds like there's a report about a backplate tamper or something that was never turned over to the defense. So I object on essentially all of those grounds.
All right, thank you. And we'll come to your object. We'll come as to whether you need more time to prepare based on the testimony on cross-examination. I think the obvious solution to that is to provide you some time once the witness testifies. So with that understanding, the objections noted for the record, Ms. Wilson, you may proceed.
Your Honor, if I could have one moment.
Sure.
So Mr. Hayes, I'd like to back up a little bit. So as you oversee JSG, correct?
Correct.
And did you receive any specialized training in order to get to that position?
Yes, I have extensive training, both by the manufacturer. I've lectured all across the country, sheriff's offices, court, district court probation officer conferences, treatment court conferences. I've been entered as an expert over 30 times at district and circuit court levels, including all 3 district courts in Ingham County and 30th Circuit Court.
Your Honor, based on that testimony, I would like to admit Mr. Hayes as an expert witness in
So pursuant to 702.
I believe so, yes.
So motion to admit Mr. Hayes as an expert in what field, ma'am?
In tether operations.
So the GPS tether operations, motion to admit the witness as an expert. Would you like to voir dire on credentials, Mr. Palmer?
I don't know that a voir dire on credentials is necessary, Your Honor. I just will maintain the same objections that I already made about preparation and materials turned over to the defense.
All right, with that understanding, and I think we're going to address the issue of whether the defense attorney and defendant have had adequate time to prepare for the witness, but pursuant to 702, MRE 702, I believe the witness has been qualified as an expert mostly based on knowledge, skill, and experience and training. And the 4 factors are met in regards to this witness testifying as an expert. And so I'll admit the expert in the field as an expert in the field of GPS tethered identification and devices.
Okay, now going back to the exhibits, looking at those exhibits, you had testified previously that based on your experience, that kind of tamper could not happen accidentally. Is that based on your expert opinion?
Correct, and specifically, I'll start with exhibit 3, which I will hold up. Here's the top of that device, exactly how I had just explained and how I removed this device. You will see that top clip, that flat portion is gone. On exhibit 2, it's a little bit closer up, which also presents a very interesting part. Same exact thing. And then exhibit 1, which is that top tamper clip. When you saw me remove that top clip here, the way that it bends up, the only way to get it not flush would be to pull. With that bottom tamper clip, that groove holding the top, you couldn't pull the top up without pulling the bottom down. So these photos, exhibit 2 and exhibit 3, you will see that it's elevated. It's not flush. It's not flat, meaning it was pulled up. It's not possible to pull the top up without pulling the bottom down. And then exhibit 1, the top piece here, the defendant had told the law enforcement, LPD, when they got there, that the piece again, Judge, I'm gonna object now. It's hearsay and he's testifying to something he doesn't have direct knowledge.
Okay, objection, hearsay response.
I have no response at this time, Your Honor. We'll
So-
just proceed.
So the objection hearsay is sustained. So just testify about not what you've been told.
Yes, Your Honor. So the only way for that to happen, again, is for the top piece to pull out, the bottom piece to pull down. In doing that, this top piece, exhibit 1, if that accidentally happened somehow, which I still have never been able to recreate, happened, you wouldn't know where that top piece is at. The only way, in my opinion, you would know where that top piece is at is if you removed it. It's a very small piece, very, very small. So we have a photo, LPD was able to retrieve that small piece from the
Now,
house.
in removing that small piece, you had demonstrated a little bit earlier, what amount of force would you say were you using to get it off?
Quite a bit. Without using a tool, it's extremely difficult. I can do it again. I can put it together and allow anybody who would like to examine it, try to pull it themselves to understand. It is not possible, in my opinion, with your finger, with a blanket catching it, with something like that. It would take effort. And that's why I brought this actual device here, and I'll put it together so that it can be demonstrated by anybody who wants to. Again, it's flush. It's not possible. I mean, even knowing that's what it is, I'm trying to put my nail in there. You can't get that groove. I tried with this as well. The only way I was able to recreate it was to pull the bottom.
And now you had said before that once that part comes off, it kind of has to detach in order for so the piece that's coming off the top, that alone would not make a trigger or report or anything to JSG, correct?
Correct. It would not do a single thing until either the strap was cut or the bottom pin was also removed, and the front and the back plate of that device comes undone.
Okay. I have nothing further for this witness, Your Honor.
All right. Now you've not moved for the admission of the exhibits. Were you going to wait till after?
I will move for the admission of the exhibits. I'm sorry, I thought we stipulated to the admission.
All right. Well, I don't know if we're stipulating now since that, so I'm going to leave that to Mr. Palmer because the witnesses that they're coming through, he's somewhat objected to because it's not on a witness list or anything. So I'm going to give Mr. Palmer the time to make a record, and B, maybe some preparation time in order to cross-examine.
Well, first of all, Judge, she's correct. I did stipulate to the exhibits. I guess the court's also correct that I did not stipulate to the exhibits through this witness because I didn't know that this witness was going to be testifying today. I do have concerns about moving forward, Your Honors, especially given the last couple of statements that Mr. Hayes gave, which is that the evidence, as I understood it, from what he said, it's not my intention by any means to put words in his mouth, but as I understood it, what we see here in the photographs would not have triggered an alert to JSG. I was prepared to cross-examine based on the materials that I have been provided. That is, these photographs and the police report that was submitted by the Lansing Police Department. It sounds like, though, that we're now missing a crucial piece of evidence. That is some sort of an electronic report that was communicated to JSG that sort of kicked all of this off. And I don't know how I can properly cross-examine a witness that, one, I wasn't prepared for, and two, that's testifying at least based on some materials that have never been provided to the defense. So with that said, of course, Your Honor, I would like, I thought that we were prepared to go this morning, right? And so I was not by any means requesting adjournment. My client's here today, but I think this fundamentally changes things. And I would like to, one, see the report before I proceed with the cross-examination of Mr. Hayes. I think that would be fair and appropriate. What I would say to the court, although I hate the idea of a delay, what I would say to the court is we're scheduled to be back here on, I believe, the 8th. Is that right? The 8th for sentencing in the case that is that this is the bond violation 2. Because of course, as we talked about, this is 1, a new case, but also 2, a bond violation to the existing case. We're scheduled to be back here on the 8th. I would ask that the court consider giving me time so that I can obtain that report.
Ms. Wilson.
Thank you, Your Honor. I don't believe I have that report. I believe that in the police report, there was mention of JSG receiving some alert, but I guess I would leave it to Your Honor's discretion on.
Well, if there's a report available, let's make sure counsel has it. He's seen that the witness testified, so he understands the nature of the testimony. I don't think that I don't have any problem with adjourning it for cross-examination purposes. You do have a witness here. Another witness here.
I do, yes.
And I think we can go forward on that witness.
I would agree with that, Judge. I certainly, assuming that the rest of the witnesses are people that are listed on the police report or on the complaint,
exactly.
Then yes, I would be prepared to cross-examine, I think, all of the other witnesses.
So what I'm going to do, Mr. Hayes, is we're going to end up adjourning this for cross-examination purposes, and you will get a new date to be subpoenaed back here for our purposes, unless you hear differently from the assistant prosecutor. So you're still under subpoena, and let's make it for that. So should we make it for that March 8th date?
It would seem to me that would make the most sense because we're all scheduled to be here anyway.
It's up to you, Ms. Wilson.
That would be fine with me. I guess I would defer to Mr. Hayes' availability.
Yeah, sure.
What time?
I believe it's set for 1:30. It's a sentencing.
Be March 8th, 1:30.
No.
If I may,
Yeah.
sentence is up for 9.
Oh, 9.
No.
I have a hearing in Eaton County at 8:45.
Reschedule it for the afternoon.
Yeah, I mean, let's.
We have a full-blown restitution hearing that we're expecting.
Okay.
And Mr. Hunt, you told me to block the afternoon.
That's not scheduled until. What time is that scheduled at?
1:30
Wow.
and 2 because we have a wedding at 1:30.
Oh, okay.
How about later in the morning?
Would 10 o'clock work?
I don't think 10 would
No.
work. That's only an hour from you. I've made that drive. About 11, would 11 o'clock work?
Yes, Your Honor.
Sure.
All right, let's set it for March 1st, March 8th. So we'll reset the prelim. Oh, and this part of the prelim will reset. Cross-examine of John Hayes and the redirect, if any, for March 8th at 11 o'clock. And the we'll let council argue over the bond violation after at that time or after that. So for our purposes, cross-examination and redirect on John Hayes, on Mr. Hayes for March 8th at 11 o'clock. And then while we have the witness here, let's go ahead and do that and do the direct and cross on that witness. Anything else for this witness today until that March 8th date, Ms. Wilson?
Not for today, no.
Mr. Palmer.
I have nothing further.
All right, you're all set. We'll see you on March 8th.
Thanks, Your Honor.
And then Ms. Wilson, you may call your next witness.
The next witness we have is, I'm not gonna pronounce the first name right, Aaliyah Barbanov, Officer Isla.
Barbanov. And Officer Barbanov, have you come forward? And have you stand right there. I'm gonna have you spell and state your first name and your last name.
Good morning, Officer Ilya Barabanov, ILYA BARABANOV.
All right, thank you. Please raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Okay, you can have a seat here. And it's Ilya?
Ilya.
Okay, thank you. Please, that microphone is for recording purposes, so please project to the back of the room if you're able. And Ms. Wilson, you may proceed.
Thank you. Officer Barbanov, are you currently employed?
Yes, ma'am.
Where are you employed?
Lance Police Department.
And what is your job position?
Officer.
What are your general duties?
Patrolling, making sure there's no crime happening in front of me, helping other people out, and then taking reports.
How long have you been in law enforcement?
Almost 2 years now.
Okay, now, were you working, do you recall, on February 15th of 2024?
Yes, I do.
Do you recall being asked to respond to an address at 1233 West Hillsdale Street?
Yes, I do.
Is that in Lansing?
Yes, ma'am.
Ingham County?
Yes, ma'am.
Michigan?
Yes, ma'am.
Okay, and what was that dispatch in reference to?
I believe the JSG company, the tether company, called in saying that the subject took off their tether.
Okay, now, so you arrived at that address?
Yes, ma'am.
Okay, did you make contact with anybody at that address?
Yes, ma'am.
Who?
I believe it was a relative. I'm not sure if it was mom or dad.
Okay.
And then we made contact with Mr. McGriff.
And do you see Mr. McGriff here in the courtroom today?
Yeah.
Would you mind pointing out and describing something he's wearing?
Black and blue coat or jacket, black sweater underneath and jeans.
Your Honor, for the purposes of preliminary exam, I've requested the record reflect identification.
Any objection to the identification of the witness for prelim?
Not for the purposes of preliminary exam.
Thank you. Okay, for purposes of prelim, the witness is identified the defendant.
Thank you, Your Honor. So Officer Barbanov, when you made contact with Mr. McGriff, did you see a tether?
Yes, ma'am.
Where was it?
On his foot.
Okay. Permission to approach the witness, Your Honor.
You may.
Now, Officer Barbanov, I'm handing you People's Exhibit 1, 2, and 3. Do you recognize those photos?
Yes, ma'am.
Do you recall who took them?
I believe Officer Hayward.
Okay. Are they an accurate and fair representation of what you saw that night?
Yes, ma'am.
Okay. Now, when you arrived at the residence, where did you, in Exhibit 1 there, you see there's a little black or plastic piece. Where did you find that?
I do not recall that. I think
Okay.
it was brought to us.
Okay. Did you get a good look at the state of the tether at that time?
I'm not familiar with others, so not much I can notice
All
about
right,
it.
that's all right. I have nothing further for this witness.
All right, do you move for the admission of exhibits 1, 2, and 3?
I do, Your Honor,
to this
yes.
witness? Any objection to exhibits 1, 2, and 3 being admitted? And this is separate from the stipulation since foundation was laid, Mr. Palmer.
I have no objection, Judge.
Okay, exhibits 1, 2, and 3 are admitted into evidence. And Mr. Palmer, you can cross.
Thank you, Judge. Good morning, officer.
Good morning.
And it's Barabanov?
Yes, sir.
Is that, I'm kind of close?
There's
or-
just different accent, but.
Got it.
yeah.
All right. How about I just call you officer? Is that fair?
Ilya.
Ilya?
Yeah.
All right, fair enough. All right, so you responded, you were dispatched to this 1233 West Hillsdale, correct?
Yes, sir.
And you were dispatched because JSG alerted, the tether company alerted LPD? Is that how that worked?
They alerted the dispatch and then dispatch.
Dispatch, all right. So it wasn't like there was some independent call for service. It was the tether company calling dispatch saying, go check on this.
Yes.
And the information that you received at that time was that the tether had been removed. Is that right?
Yes, I believe so.
All right. And so you responded, it's of course, whatever, roughly 5:30 in the morning or so. It's early morning hours. Is that fair to say?
Yes, sir.
And when you responded, what, for example, do you recall, were there lights on in the house? Did it appear that people were up and awake, or did you have to wake people up?
I do not recall there being any lights in the house.
Okay.
And I do believe you probably had to wake people up.
Okay. And you indicated that the first person to come to the door was some relative. Is that right?
It was a female.
A female. And it appeared, at least for your perception, I know you don't necessarily know who that is, but it appeared from your perception that it was a family member of some sort.
Some sort of relative, yeah.
Got it. And did Mr. McGriff eventually come to the door?
I believe that same relative that opened the door called him down, yeah.
Called him down. And when you say called him down, did you like then witness, for example, him coming downstairs or something, if you recall?
I do not recall.
That's okay. Do you remember what Mr. McGriff was wearing when you first made contact with him? And what I'm getting at here is, was he, for example, wearing boots and jeans, like and a jacket, like he had just gotten home or was getting ready to leave, or did he appear to be more in like sleepwear?
Not recall.
Don't recall. Okay. And at the time you made contact with him, presumably you advised him of why you were there, right?
I believe so, yes.
And the only reason, I guess, just to confirm, this seems straightforward, but the only reason you were there is because of this alert from the JSG tether company.
Yes, sir.
And when you encountered Mr. McGriff, you asked him about the tether, yes?
Yes.
And you observed Mr. McGriff with the tether on his ankle.
Yes.
All right. And I know you indicated that you did not, I think, and I don't mean to put words in your mouth. I think the way you said it is you're not super familiar with tethers. Is that right?
No, sir.
All right. No, sir, as in no, you're not familiar with tethers.
No, as I'm not familiar with
All
tethers.
right. Was it immediately apparent to you, even with your like sort of lack of knowledge about tethers, was it immediately apparent to you that the tether had been tampered with?
All in that little piece being broken off? No.
Okay. And did it come as a surprise to you, given the basis for your dispatch? Did it come as a surprise to you that the tether was still on his ankle?
Yeah.
Yeah. And then at some point you were provided with that. Judge, could I approach for the exhibits?
Yes.
And officer, at some point, I'm handing you, may I approach the witness, I'm sorry. I'm handing you exhibit 1. At some point, you were handed this little plastic piece, right?
Yes, sir.
And that, do you recall how you were provided with that little plastic piece?
I do not recall.
All right. You would agree with me that that's, I mean, first of all, the photo shows a very small piece in the palm of a person's hand, right?
Yep.
And is that your hand or your partner's, if you recall?
Maybe mine.
Okay.
I do not recall.
At any rate, I guess the point being, it's a normal sized human hand, and it fits very smallly in that palm, right?
Yes, sir. I believe it was like half an inch to an inch,
half an inch. And do you remember how thick it was?
maybe a centimeter or two.
So it's quite thin.
Yeah,
And it's made out of plastic?
I'm not sure.
Okay. And may I approach the witness to retrieve the
You may.
exhibit? And maybe I asked you this and I apologize. You indicated that you were provided with that piece, but you don't know who provided it or how you provided it?
Do not recall if it was given to Officer Haber or me
Okay.
initially.
It was given to one of you. Do you remember who gave it to you? In other words, did Mr. McGriff give it to you?
I think Mr. McGriff gave it to us.
All right. And I'm not to be clear, I'm not asking you what he said, but when you made contact with him in this early hour, did he appear to be, for example, groggy? Did he appear like he just woke up? It's okay if you don't know, you don't know. That's fine.
I don't know.
Okay, fair enough. And then at some point, you or your partner made contact with the JSG Tether Company. Is that right?
Yeah, I believe it was me.
Okay. And again, I'm not asking you for the word by word accounting of what that conversation was, but you were advised, despite your own personal beliefs, you were advised that there was a basis for to arrest Mr. McGriff based on a tamper. Is that right?
Yes, sir.
And you were also advised, for example, or at least you put in your report that you were advised to just take this piece in Exhibit 1 and just throw it away, right?
Yes, I asked them and they did not need it.
They did not need it. And when you took Mr. McGriff, did you remove the tether from Mr. McGriff's ankle?
No, I think it stayed on.
It stayed on. And then Mr. McGriff was then placed in handcuffs and transported to the Ingham County Jail. Yes?
Oh.
Or I'm sorry, LPD jail. Yeah. But he was transported to jail, right?
Yeah.
And that tether remained on his ankle the entire time?
Yes.
Well, I guess I'll ask it this way. It remained on his ankle for as long as he was in your custody, and it was still on there when you turned him over to the jail, right?
Yes.
So in other words, you don't know if or when it was ever removed after that point.
No.
And you don't have any personal knowledge of, for example, what happened to the rest of the tether that was around his ankle?
No.
Thank you, Your Honor. I have no further questions.
Any redirect, Ms. Wilson?
None, Your Honor.
May this witness be excused from the people,
You may, Your Honor.
from the defense?
Yes, Your Honor. Thank you.
All right, thank you for your appearance today. You're all set. Any further witnesses today from the people?
No, Your Honor.
Any proofs today, understanding that we've adjourned this to that March 8th date from the defense?
Not today, Your Honor. I guess I would ask that the court allow me to reserve that we potentially will put on proofs, I guess, on the 8th if necessary.
Right. So, yeah, we've adjourned this to March 8th for a cross-examination of Mr. Hayes to allow for some time. So the prelim is adjourned to March 8th, pursuant to giving counsel some time to look at the testimony, maybe some discovery if available, and we'll regroup on March 8th at 11 a.m. So we're adjourned to March 8th at 11 a.m. So that's all for the record in docket 24-00405. And then we have the bond violation of 23-03590. And Ms. Wilson, how are we proceeding on the bond violation? We've now had some testimony concerning that, but we've not finished the testimony.
I believe it would be appropriate to hold that until that March 8th date to give defense an opportunity to cross Mr. Hayes.
All right, and Mr. Palmer.
I would agree with Ms. Wilson. I think that's fair and appropriate. I would also point out, I don't think that there's any concerns about Mr. McGriff. Despite this allegation, Mr. McGriff has appeared for every court date. He does actively have a GPS monitor on now that apparently JSG seems to agree with. So he's showing up for every court date. I would ask that the court allow us to move that bond violation to the same time.
All right, so we're going to set the bond violation for the same time on March 1st at 11.
Yeah.
March
11
8th.
March 8th. I'm getting it. So March So this is adjourned to March 11th at 8 a.m. at 11 o'clock. And for continued testimony on, yeah, I believe his name is John Hayes. Is that correct?
That's correct.
All right.
Yeah.
Anything else for the record in docket 2303-590, Ms. Wilson?
Your Honor, do you want to hold on to the exhibits or do you want me to take them?
I'll let you take them. And we'll revisit this on March 11th. We have the prelim and then, and this testimony coincides. So I think that's fair that the cross-examination be, but we'll also address the bond violation at that time. Anything else, Mr. Palmer?
I have nothing further to do. Thank
All
you.
right, we're all set. We'll see everybody on that March 11th date at 11 o'clock, and you should get notice from my court officer.
Let's go talk.
Is Tether?
Oh, I'm sorry, I was like.
I don't think there's, unless you want another prelim.
Oh, I didn't have like, I wrote like, old school notes, like, when you were just.
I know.
Oh, okay. The one that testifies to his company.
Gotcha.
His employees don't have to testify.
Gotcha.
Unless
Okay.
they're like an eyewitness.
Gotcha.
It gets confusing, I know.
It does,
And
yeah.
people forget what people don't know, and so
Yeah.
you're not told things,
Right.
so I'll send an email out.
Okay, thank you. Do you want to go on pain?
I can, or if you want to.
I need that.
Okay, that's fair, yes, I can go on pain.
All right, so Mr. Cornish, you're here for Mr. Sartz?
Yes, Your Honor.
All right, so we're on the record in docket 24-00396. That's people of the state of Michigan versus Mark Payne. Will the parties please introduce themselves for the record?
Your Honor, I think
Miss-
we need to get Mr. Payne up from lockup.
Oh, we have, oh, he's got to be brought up?
Yeah,
Let's
but
do that.
can I approach Miss Holden?
Sure. Give some exhibits.
I have one. Is there an ability for us to play this on the big screen?
Yes. The cord that goes from your computer to that big screen, I think Mr. Cornish is looking at it right now.
Oh, fancy. Thank you, sir.
Body camera.
It is not. It is security footage, security video.
Thank you.
Sorry, this is probably a safety hazard. I should.
So we'll get Mr. Payne up and you can have some, you can talk to him if you need to. We'll take a 5-10 minute address adjournment, okay?
Sounds good, Judge. It's almost gone anyway. I should just kill it.
Chug, chug, chug.
It's just like a, what, you left me with? That's all I want.
Of course you do, right? Yeah.
Pardon?
I said I met him yesterday, so I'm just going downstairs.
Oh, okay. Do you want
He
to?
said 5-10 minute break. I watched this all yesterday.
Okay, I just made a 3-minute clip from the big one. Yes.
That's what I
Okay.
figured you do. I appreciate it.
Yep.
I'm here for an hour.
Right? Thank you for your patience. I'm sorry. I know this takes forever.
Yes, I know. I just never knew it was this long. Look.
Last week, my case was set at 8:30 a.m. and I did it at 3.
Oh, my goodness.
Yeah, and that was after we worked through lunch.
Yes, I'm missing work and everything. But good
Thank
thing
you.
I got it
Why is
lined
it so
up.
light all of a sudden?
Yeah.
Yeah. No, thank you.
So y'all lunch 11:30.
It just depends. Yeah. Some judges take them, some judges don't. Like if, I mean, they won't make you go through lunch, but if everybody just wants to continue, sometimes they'll do like, okay, we'll take a 10-minute break, everybody go get a drink and come back. But usually between like 11:30 and 12:30, but what we're getting ready to do should be very, very quick, so you should be able to get in before lunch. We'll go more than 10-15 minutes.
I have to find the app for the parking meter. I have to go down somewhere.
Oh, yeah, I know.
Like, I don't want to keep going down.
Well, and then half the time the app is like not working and.
Yes, the thing is, it took me a long time to find it. I'm like,
Yeah. It's really nice when it works, because like, it used to be the same for us, like if we drove over here, we'd be in the middle of court, and you'd have to be like, Your Honor, can I have a 5-minute adjournment so I can go put money in the meter, and then they get super annoyed at you, and so now you can at least kind of like do it slyly while you're on the record, but then the app doesn't work, or you've parked there too long, because when they first put the spots in, they were 2-hour max, and so you come here and you're like rolling the dice if you're gonna get done in 2 hours or not. So paid a lot of parking tickets.
They're ruthless.
They are ruthless.
Then when I was going out, the car was pulling right up to see if I was, just see if it was valid. I'm like, let me hurry up.
I was literally still on the sidewalk looking at my car like,
got a
on the
ticket.
app, and she put a ticket on my windshield. And then I went up to her and I was like, look, I'm paying. She goes, you can't talk to me.
Oh,
and I was like, okay, I'm
You
sorry.
didn't do the whole.
I don't abuse my authority like that, Mr. Cornish.
You know who I am.
They don't give a
I am busted.
I know, but they really don't. Like,
That's why I said, let me hurry up and get to this meter.
You
Then when I see her, I will
pull,
leave.
you don't ever come before me.
so now I sit in my car and do it. Like I will not get out of my vehicle until the payment has gone through.
Right.
Because I'm like, they're not gonna ticket me with me like physically in this car, are they? Like, they might.
Right.
The audacity is
They get that
unmatched.
parking meter show, so.
You're like, look, I just pulled in, bro.
And then, so then I went to the office, because I'm not allowed to talk to her. So I went to the office and I showed her, I'm like, this ticket was written a minute after my parking like went through. I was literally standing there watching her give me the ticket. And she's like, well. I was like, so are you gonna like do anything? She's like, yeah, I'll take it away. And I was like, okay, can I get like a receipt? I was like, I would like proof that you're dismissing this so that I don't get a late fee or something. She's like, we don't do that. That's the next. I was like, oh my Lanta. I did not know I was asking the world right now. Apparently I was. We are indeed ready.
Did you see the mock-up of the new courtrooms?
No.
So they're gonna be separate tables, podium, so we're not like elbowing each other.
So
while
more
we're
like
trying to talk.
more like 55th.
Yes, very much like
Nice.
55th.
Cool.
The only
Does
thing
it
I asked-
swivel the podium?
Yes.
Yeah, nice.
The only thing I asked for is that the pews have an incline to them, because 55th is a perfect right
Yes,
angle.
and
you
they're
sit there
very
like this
uncomfortable. Yeah,
While you're sitting in court, you're like, man, this hurts.
yeah. If you're not like real thin, it's very uncomfortable.
But you have to use the court voice because the judge is like 20 feet away from you.
Yeah. Well, they probably have better mics. They'll be like 55th where they actually pick up stuff.
There's sound mics I asked,
Nice. Yeah, I don't like these ones.
but just reports.
Yeah. Well, they don't,
There's no
if you're
button.
not like right up on top of it, I feel like it's not the best.
I usually put it in the,
I'm not a quiet person, so I don't have to worry about it, but
Tammy Marsh said I was the second lowest person.
I was probably first.
Scott
Okay,
was
that's
very
fair.
loud.
And Adam. I think they might be in their own category though.
Yes, I said, Scott, you can count.
Not only does he not count, he's like in a different decibel. I just want him and Adam to just only have cases together, just because it would be so funny to watch.
I like it when it starts.
You're cruel. That's called bad employee retention right there.
I'm here covering with this hearings today,
That's fair.
and I got a half win on the first one. Reduced.
Okay,
Not
I'll take
win,
that.
I'll take that one.
I'll take a half. None of this one, well, you know.
So for that.
Hmm.
So I'll take that.
Yeah. Ugh. Will they get an announcement?
Yes,
Okay.
yeah, I think so,
Okay.
yeah.
Sorry, I didn't realize that.
No,
had
you're
been
totally
worked
fine.
out.
They, I mean, you were sitting here when we said it, so I don't know where I thought, but whatever.
There's good stuff there.
Yeah.
Yeah.
Oh.
Very,
Yeah.
very like spot on.
Yeah.
I'd be very sure. I've had quite a lot of experience with that syndrome.
Rise. Be seated. All right, so we're on the record in docket 24-00396. That is People of the State of Michigan versus Mark Anthony Payne. Will the parties please introduce themselves for the record from the people?
Thank you, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people.
Good morning. Good morning, Your Honor. May it please the court, Deputy Chief Public Defender Steve Cornish on behalf of Mr. Payne, who's in the court and seated to my right. Mr. Sartz will remain the attorney of record I'm covering today.
All right, thank you. And sir, you are Mark Anthony Payne, is that correct?
That is correct, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Smith, how we proceed?
Thank you, Your Honor. The people are prepared to proceed to a preliminary examination today. That will just be in part. I've let defense know this ahead of time, but the first reporting officer and key witness, Trevor Arnold, was on a pre-planned vacation for this date. He did let me know ahead of time. And like I said, I informed Mr. Sartz. His testimony will be required at a further date. I also spoke with the victim, Miss Milliken, this morning. We had not previously been in contact. She had to change her number due to this incident. And so she provided me a new phone number and a new address today. So I will be sending her a subpoena for the second date as well.
All right, so there'll be a second date, a request for a second date after testimony taken today. One is from a pre-planned officer's vacation that was previously indicated to counsel. And the second would be a new witness that's been stated on the record, Ms. Mulliken, and you're going to subpoena that witness.
I am, Your Honor.
Is that a fair statement, Mr. Cornish?
That is a fair and accurate statement, Your Honor. I understand the court rule allows for such as long as they begin it within the 21 days. So I guess I would leave that to the court's discretion and the
Okay.
following of the court rules.
All right. Are there any preliminary matters to come to the court's attention?
Your Honor,
Ms. Smith?
Your Honor, people only have one witness, Detective Wilson, who will begin today's exam, but I have no objection to sequestration if Mr. Cornish is requesting it.
All right, Mr. Cornish.
I would be requesting that specifically. I know that the court from time to time puts these on YouTube for the openness to the public. I'd ask that not be posted until after the conclusion of the second part of the preliminary examination, specifically because there may be lay witnesses or other officers testifying that, not that they would, but could go back later and review that online before coming and testifying themselves. So
All
that's
right.
not be put online.
Response, Ms. Smith.
No objection.
That seems to be a reasonable request to me. So we will allow the live stream to keep going, but we won't post it till the entire prelim is done.
Thank you, Your Honor.
You can call your first witness, Ms. Smith.
Thank you, Your Honor. I would call Detective Wilson.
Right, Detective Wilson, I'm going to have you come forward here. And please state your full name and spell your first name and your last name for the record.
Detective Sarah Wilson, SARAHWILLSON.
Okay, please raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, please have a seat. The microphone is for recording purposes, so please project to the back of the courtroom. And Ms. Smith, you may proceed.
Thank you, Your Honor. Detective Wilson, can you please tell us how you were employed?
I'm a detective with the City of Lansing Police Department.
How long have you been a sworn officer?
Approximately 15 years.
And how long have you been a detective?
About 4.5 years.
In the course of your duties as a detective, do you often draft and execute search warrants?
Yes, I do.
And how do you do that?
Depends on the case. Generally, I essentially put together a search warrant with what it is I'm looking for and the probable cause that supports that, and forward it to a prosecutor for signature and then a judge.
And did you obtain a search warrant in the case regarding Mark Payne?
Yes, I did.
And what was that search warrant for?
It was for a surveillance camera that was taken from a hotel room where the assault for the incident I was assigned occurred.
And did you in fact get that surveillance camera search warrant signed by a judge?
Yes, I did.
And was that surveillance camera processed?
Yes, it was.
Did you review the contents of the return of the search warrant?
Yes, I did.
And there's a still screenshot here on the TV from People's Exhibit 1. Does that screenshot look familiar to you?
Yes, it does.
And can you tell the people and the court what that video will contain?
It is footage of an assault that occurs on the victim is the female Rosemary Milliken, I believe, and the male was identified by her as Mark Payne.
And I'm going to play just a bit of it before asking for its admission, just to ensure that this is the video that you received.
What she do, right? Yeah. Okay, I'll make sure I hear you for a while.
Does that appear to be consistent with the video you received?
Yes, it does.
People would move for admission of Exhibit 1.
Any objection to the admission of People's Exhibit 1, which I assume is a jump drive that has the video on it?
Yes, a USB, Your Honor.
Mr. Cornish.
I don't have any objection. I'd just like to know, I know the video is much longer. We're playing a snippet. I just want to know what the times were that we were playing from start to finish.
Absolutely. I
Sure.
can note for the record that although it's transposed on the bottom, I think just by nature of how these get recorded, that the time this video starts is reflected as 11:13:52 p.m. On the date of 12, I believe that's 8 without the volume button there, 2023. And it is exactly 2 minutes and 49 seconds of, like Mr. Cornish said, a much longer video.
2 minutes. And my only question to the witness is, what date did you get the search warrant?
I obtained the search warrant. I apologize here. Let me think here. Boy, I delivered it to, let's see, on the 15th. It was approximately December 15th. I would have
All
to
right.
refer to my report.
All right.
An exact date for your own.
All right, with that understanding, a Exhibit 1 is admitted into evidence, and you may publish, Ms. Smith.
Thank you, Your Honor.
Of course you do. I yeah. I'm gonna make sure I hear you for a while. Yeah. Of course you do. Of course I am. That's right.
Because you don't act fucked up enough. Because you're not enough of a fucking dick. And I really don't do shit to you. And I don't fucking talk shit about you. I fucking do everything you fucking tell me.
Don't tell him that.
You can shut the fuck up and quit fucking bitching at me.
I'm done talking to you. What you talking about? I've been done 10 minutes ago. You should have said that shit 10 minutes ago.
Yeah.
That shit ain't good.
Because you got the shitty attitude. It's fine.
Fuck you. You got
fuck you,
bitch. You didn't like what I said.
No.
Yeah, you didn't like what I said. Now you
no, because you're fucking wrong.
So if I slap
because you're fucking wrong.
Out your
I will slap you back.
If I slap
I will
out your
slap you back.
Bitch, you gonna be
I will
slick.
fucking slap you back.
You
You already know.
Bitch,
I'm done with this bullshit.
Bitch, you gotta
I will fucking fight you back, bitch.
Shut the fuck up. Bitch, shut your dumb ass up. Bitch, you won't get another piece of crack.
I don't give a fuck.
Bitch, I should knock you the fuck
do
out.
it.
Bitch,
Do it.
I just want to.
Do it so I can hit you back.
Bitch, you ain't
Do
gonna
it so I can hit your ass.
And for the record, Detective Wilson, you were able to observe this, correct?
Yes, that's.
And can you just indicate to the court what you just saw in the video?
It appeared that he struck her in the head.
And to your understanding, who are these people?
Rosemary Milliken and Mark Kane.
Thank you.
So I can fucking hit your ass back. I'm not the one standing up.
You ain't gonna
I'm not the
make
one
me.
getting in somebody's face raising a motherfucking hand either.
Out of my face, bitch. I'm gonna.
And can you explain to the court what you just witnessed after the male struck the female in the face? What happened after that?
It appeared he also kicked her in the face.
Oh, still swinging, huh? Still swinging, huh? Still swinging, huh? Still swinging, huh?
Yeah, good. Stop, Rosie. Margo, stop. Stop it. Margo, stop. Margo, stop.
What am I?
Stop. Don't do it. Margo, stop. Rosie, stop. Margo, stop. Bro, stop.
Oh, you talking about business?
Margo, come on. You're the one starting shit. Stop. You're the one starting shit. Come here. No, come on. You're getting in mine.
You talking fighting words?
You're getting in my fucking face. Acting like a fucking dick. Over your bullshit. Your fucking bullshit. Yeah.
Come on. All of
After the male struck the female in her face with his foot, what did you witness on the camera?
He got up and he kind of cocked his arm back like he was going to strike her. It appeared he did not strike her and that she actually reached back and struck him. And then he came forward at her and they fell to the floor.
And during the course of the next 60 to 90 seconds, what did you observe?
It's hard to tell because they're off camera, but it appears that he's on top of her and he talks about, oh, you're gonna keep fighting, huh, or something, or keep hitting, something to that effect.
And a third party walks out of the bathroom, correct?
That's correct.
And what is she screaming during those 60 to 90 seconds?
She's telling them to stop. She uses the name Mark and Rosie, telling them to stop.
And who do you observe getting up off the ground first?
Mark, Mr. Payne.
Have you had any firsthand, meaning face-to-face or on the phone contact with Mr. Mark Payne?
I have not.
Have you had any interactions with Rosemary Milliken?
I have not.
Did you execute a search warrant or other type of request for medical records in this case?
Yes, Officer Allman had received or obtained a signed medical release form from Rosemary, and I was able to obtain her treatment records from Sparrow.
Thank you. I have nothing further.
Cross-examination, Mr. Cornish.
Very briefly, Your Honor.
Thank you.
Morning.
Good morning.
You would agree the video pretty much speaks for itself, is that correct?
That is correct.
In the video, we see my client, allegedly my client. The only reason you know that's my client is because someone else told you it was my client.
That's correct.
Okay, so you see the gentleman laying on the bed in the video, and he's laying on his back, is that correct?
He's mostly on his back, yeah.
Kind of propped up a little bit?
That's
and
correct, yes.
Kicks in an upward position, according to what you were testifying to earlier,
Yes.
correct? And strikes somebody in the face.
Yes,
That person didn't fall down.
that's correct. He did not fall down.
We don't see on the video blood splattering across the room or anything.
That's correct.
They just kind of like jerk back a little bit, and then immediately the two of them begin, I guess, an affray at that point, as I would call it, or a fight.
Pretty closely after, yes, yeah. He stands up and cocks back his arm, and then she swings and hits him.
And at that point, they're on the floor. You can actually hear him saying on the video stuff like, "Are you going to keep hitting me or punching me?" Something of that nature.
Yes, that's correct.
Nothing said about her being choked on the video or strangled. I'm sorry.
I didn't hear anything specifically on the video, no.
In fact, she's continuing to talk back and forth throughout the entire thing.
You can hear her talk at times, yes.
You don't see him get up and start stomping on her or anything, correct?
Not that I can see on the video, no.
So what we see is it kind of looked like a cuff or a slap to the side of the head earlier in the video, correct?
Correct,
And then a upward kick in the video,
correct,
and then the fight.
yes.
Thank you, Your Honor. Nothing further.
Any redirect for Detective Wilson, Ms. Smith?
Just briefly, the male hit the female first, correct?
Correct.
Both with his arm and hand and his leg and foot.
Correct.
And then what happened after was an assault, not a fight, correct?
Yes, I mean, it appears.
That calls for a legal conclusion.
Would you categorize it as a fight or an assault?
That calls again for a legal
Yeah.
conclusion.
Well, however the officer sees the video with the understanding that the court's not moved one way or another. And then any descriptive as to why she calls it that. So I'll overrule the objection. I'm going to decide the legal conclusion,
Understood, Your Honor.
but the detective can indicate what she saw.
In her training and experience, what would you indicate it as?
I mean, it appears to me to be an assault based on the fact that he's on top and she apparently doesn't have the ability to physically even possibly get out of this situation until he gets back off of her. It appeared to me to be an assault.
Thank you. No further questions.
Any cross on that final answer? All
No,
right.
Your Honor, thank you.
All right. May this witness be excused from the people,
Yes, Your Honor, thank you.
from the defense?
Yes, Your Honor, thank you.
All right. You may be excused. Thank you for your appearance today.
Thank you.
Any further witnesses from the plaintiff?
Not from today, Your Honor. We would again just be requesting that second date.
All right. And any record you'd like to make, Mr. Cornish, concerning the second date or time frame? Do we have a time frame for that?
Your Honor, I believe that the officer indicated to me that he would be back in town late next week. So if I could request at least 2 weeks, that would be really appreciated.
And then, Mr. Cornish, you're covering for Mr. Sartz. So I don't know if this is something you're going to keep or if Mr. Sartz is going to come in. But I want to put it out at least so you have the opportunity to see who's gonna finish the preliminary examination and then make argument.
Thank you, Your Honor. It very likely will be Mr. Sart's taking it back over. I may come with him just so I can, I guess, help him. understand what occurred today, although it wasn't a substantial amount of testimony. I think that he's more than capable of taking back over. I do have his schedule here if we want to look at a new date.
All right, so let's at least 2 weeks out, past 2 weeks, which should work fine with us. And then get a date to see if Mr. Sartz is available.
March 28th at 1:30.
March 28th at 1:30. How does that date work?
It's fine for the people.
Mr. Cornish? I know Mr. Sartz has a trial schedule.
Pardon? Just got scheduled because I don't have my calendar yet, but I would believe it if it's there.
I think they both
I
have
think they
pretrial.
both
that
are
afternoon.
in
So
pretrial.
let me just check. If we want to go the following week, though, I believe that's good.
Would the 4th work?
The 4th is wide open. For
Your
Mr.
Honor,
Sutton.
I do have a training with the ATF in the afternoon. Do we have anything in the morning on the 4th?
We might.
8:30.
8:30 is perfect for
8:30.
me.
That's
Okay.
excellent, Your Honor. Thank you.
Yeah, April 4th at 8:30 for the continuation of the prelim.
Thank you so much, Your Honor, for the flexibility.
Anything else for the record in docket 24000396?
Not from the
Ms.
people, Your
Smith
Honor.
and
Thank
Mr.
you.
Cornish.
Not today, Judge. Thank you.
All right, we're all set. We'll see everybody back on April 4th.
Thank you
Your
so
Honor.
much.
If we could bring up Mr. Brown.
I'll get that search warrant to you today if I have it. If I don't, I'll request it.
It's got a page in my
Okay.
the last one. The next one's Mr. Brown.
Correct.
Mr. Silverthorne, have you had any luck with Mr. Collins?
No, I have not.
All right.
It is not the one I'm trying.
We can probably, I'll leave it to your discretion. If you want to call him now or call him after Mr. Brown's case.
You can call it now. And I'll just
All right,
put on the record.
all right. So we're on the record in dockets 20. Let's see, Mr. Collins. We're on the record in docket 24000406. That's people of the state of Michigan versus Robert Collins. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Mr.
Wait.
Silverthorne.
Wayne Sullivan from the Office of Public Defender on behalf of Robert Collins, who is not here. If I could make a brief.
Please.
record. I had difficulty getting Mr. Collins to court last Friday, as Ms. Wilson would probably attest. He did show eventually afterwards, and we just considered the PCC treated and then extended to this week. I have spoken to him numerous times this week, most recently this morning, when I called him to remind him that he had court this morning. And here's my error that I had told the court at the bench, but I'll make it a record. I had indicated him that I thought it could be done by Zoom, and I reread and gave him the Zoom number, which apparently he did get. It was apparent he was in his car at the time he was headed to the court. The next thing occurred shortly after around 9 o'clock when I came in for the PCC. Apparently he was on screen, but couldn't get audio. And your court officer indicated, well, he needs to be here. And at that point, I remembered this is a PE, a preliminary exam date, not a PCC date, even though we have it all resolved with the plea and everything. And from there, I have called his mother 2 or 3 times. I have texted him. I've called and left messages. It rings and then goes to, it just goes to voicemail. I don't know the reason. My suspicion is he either didn't know how to work the Zoom or had a prepaid phone with limited time. But still, he would know then he should just show up to court. And I've spent the better part of 2 hours attempting to do that. So what I would ask of the court is what Judge Buchanan did last week, is she issued a bench warrant, but held it for 48 hours because he very likely might appear. I'm going to go back to my office. I will be at my desk entirely if he were to show up, I could, and we're notified, I could zoom in immediately and just move this case along to the circuit court.
Ms. Wilson.
Thank you, Your Honor. Given Mr. Collins' somewhat failure to appear at the last date, I understand that he did eventually appear, but it did take some trying again on Mr. Silverthorne's part. I don't necessarily believe that he's a good candidate for a 48-hour hold at this point. There seems to be an issue with him appearing for court, so I would request an immediate bench warrant.
Thank you. Mr. Collins did appear briefly. I know that on Zoom, but he was not able to connect. And given the circumstances, I'm going to indicate that the defendant failed to appear. This was scheduled for 8:30. It is now 11:03. I do not see Mr. Brown in the Zoom courtroom, physical courtroom, or the waiting room. But based on a late appearance and then a somewhat appearance today, and we have some question as to the information that was received, I will issue a bench warrant on this time, but I'll issue it with a 48-hour hold as requested. And then that'll give Mr. Brown a little bit more time to get in contact with Mr. Silverthorne. If we lose contact and when you understand, then the bench warrant goes into effect.
Fine, Jared, thank you. I will, like I said, I will be back to my office. I can zoom in.
Okay.
Within a moment's notice, because again, I'd like to take care of this, although I don't wish to extend Miss Wilson's day here. So if she's gone, she's gone.
Right. If
I would not expect her to, it's not her client. I would not expect her to stay.
Right. Well, with that understanding about if and we'll be available, but we'll see if Mr. Collins, if you're able to get a hold of Mr. Collins.
I'll be resuming my efforts in about the 10 minutes it takes me to walk back to the office.
All right. Anything else for the record? 2400370. Ms. Wilson.
Nothing from the people.
Mr. Silverthorne.
Nothing, Your Honor.
All right. Thank you. And then Mr. Oh, we have to bring up Mr. Brown. Very good.
You give me Mr. Brown's. Would you like me to write it? Okay. When? Oh, you got right here.
Collins. All right, so we're on the record in docket 2400370. That's people in the state of Michigan versus Lamar Brown. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Ms. Wanchi.
Melanie Wanchi for Mr. Brown, who's sitting at the council table.
And sir, you are Lamar Brown, is that correct? Thank you. This is the time set for a preliminary examination in the matter. Ms. Wilson, how we proceed?
We are proceeding with the exam today, Your Honor.
All right. Are there any preliminary matters to come to the court's attention before we get started, Ms. Wilson?
Briefly, Your Honor, depending on how the proofs come out today, there may need to be a continuance for additional witnesses.
All right. Ms. Swanji, anything from the defense perspective?
No, Your Honor. Thank
All
you.
right. I'll do a motion for sequestration. So if there's a potential for a witness to be a witness in this matter, they shouldn't watch another witness testify unless the court knows about it and agrees to it. Other than that, Ms. Wilson.
If I may, Your Honor, if the court will do the same thing that it did, not post on live.
That's fine.
That's fair. Reasonable request is that the entire preliminary examiner will not be posted until it's complete.
Thank you, Your Honor.
Anything else? All right. With that understanding, you may call your first witness, Ms. Wilson.
Thank you, Your Honor. The people called Michelle Thomas.
Judge.
Thompson, sorry.
If they turn it off, then I can't break it into pieces. The live stream.
Oh, you can't do like a part one and a part two.
It just has to